President Cyril Ramaphosa's attempt to block his predecessor's private prosecution bid against him will resume in the High Court in Johannesburg tomorrow. Ramaphosa's lawyers have argued that former President Jacob Zuma's legal action is frivolous and threatens public confidence in the office of the president. Zuma's accused Ramaphosa of failing to investigate arms deal prosecutor advocate Billy Downer for allegedly leaking his medical records to News24 journalist Karen Moon. The former president's advocate, Dalimpofu, hit out at Ramaphosa and said that he should have pleaded first before taking this challenge to court.
The first proposition I want to make is that the phrase title to prosecute is not an invention of my learned friend Mr. Maineche or me or anybody. It's an invention of Parliament. And the only place you're going to find that phrase in the entire body of law of South Africa is in 1061H. Right? So let's be clear about that. Title, if it's true that there are cases about title to prosecute, where do you go? If you Google title to prosecute in all the law of South Africa, it's going to take you here, 1061H. It says, when an accused pleads to a charge, he may plead H, that the prosecutor has no title to prosecute. That's exactly what they are doing. They are saying that the prosecutor has no title to prosecute. But they can't do that now. They can do it when an accused pleads to a charge, which then deals with both of Mr. Muela's point and mine. That the when pleads to a charge, where is that done? It's never done here in the civil court. It's in the criminal court. Secondly, when they plead, it's not now. Even if this was the criminal court, they couldn't raise it now because it can only be done when you plead.
Let's get you more on those proceedings in the High Court. Ziyanda Ngcobo has been tracking the story for us. She's with me now in studio, Ziyanda, and much of the challenge that the president has brought against Zuma in trying to get this interdict talks about the issue of timing, why it was that Zuma brought it around the timing of the ANC's conference where Ramaphosa was seeking re-election.
Absolutely, and you'll recall that this is exactly why the president is saying that this litigation is actually vexatious and has an ulterior purpose. They believe that the timing was of the summons was so that it could influence the outcomes of the ANC's 55th National Conference. But actually, Dalimpofu saying, outlining the sequence of events, saying that both legal teams, at the very least, agree on the sequence of events that took place. The first Nolly Prosecutor certificate being issued on the 6th of June, and then outlining the various stages at which led then the KZN Director of Public Prosecutions issuing the second Nolly Prosecutor, just to explain why there are two certificates of non-prosecution, which are one of the 4 prerequisites needed before you pursue a private prosecution. Mm-hmm. The first one basically spoke about the DPP's intention not to prosecute Billy Down as an individual. Then right. Zuma's lawyers wrote to her to say, Elaine Zungu, who's the KZN DPP, to say, well, actually, does this also include Karen Moon, who they believe should have? And then the second Nolly prosecutor said, anyone involved in the matter. Now, these words are very important because they say anyone involved in the matter cannot include all South Africans, 8 billion
it's not
people.
A blanket
it's not a
certificate.
Blanket certificate. They're saying those who are either accomplices or accessories after the fact, which is what they're saying President Ramaphosa is, then it should include him. So they're saying it actually, includes, extends to President Ramaphosa. In fact, today, Mpofu being lashed outside by the judges for his language, but he has said in court papers describing Elaine Zungu's conduct as disgraceful. Let's listen to what he said earlier.
Then we had to threaten to say, if you don't issue the new certificate, you're going to be compelled to do so in a court of law. Please give us the new certificate on the 11th of October, of November. Again, they default. This time, I suppose we must be grateful, only by 10 days. They give it on the 21st of November, right? The former president tells this court that I received something he has been asking for all year. Now we're told about Nazareth. There was no Nazareth when he was asking about this thing from April, May, June, July, August, September, October.
So, Ziyanda, let's talk about the separation then of Ramaphosa, the head of state, versus Ramaphosa, the individual, because his legal team says all of this basically could have a bearing on the office of the president, but Zuma's legal team claims that what they're going after is Ramaphosa, the person. How does that work?
Exactly. So, you know, with private prosecutions, usually it's also you're going after an individual, just like how the former president is going after Karen Moore and Billy Downer. The same applies with President Cyril Ramaphosa. However, the president's lawyers are saying, well, yes, he is an individual, Cyril Ramaphosa, but this Cyril Ramaphosa also happens to be the president of the Republic of South Africa. And by implication, when you're the president, you are the you're the bearer of the Constitution and constitutional rights. So, one, they argue that these summons are aimed at you know, instituting harm, personal harm against the president, but also it has implications for the office of the president. And this is why then, instead of the president seeking his own attorney separately, the state's attorney is representing the president because he is someone who occupies that office. So, and by extension then, that this also has an implication on his functions within the government, because if you privately prosecute the president, then there are so many other processes that could be instituted even at a party political level, the governing party with the step-aside guidelines. So let's listen to what Ngwako Mainesh had to say about that.
There is public interest in ensuring that the president performs his functions as required and he is not prosecuted unlawfully for the performance of his function, and that he is not subjected to an unlawful private prosecution by a private individual. There is a direct public interest in that, and the government is certainly interested in that. The office of the president that he occupies has a direct interest in such a proceeding. So the state attorney is quite rightly involved in this case to act for the president. So we submit in summary that the objection on standing, both of the president as an individual and as an occupant of the office, and the objection to the state attorney's involvement are all unmeritorious, and the court should not hesitate to dismiss them.
A good place to end in, Ziyanda, while this case is continuing, is on the issue of jurisdiction, whether this High Court is even the right place for all of this to be happening.
So this court is the right place for all of this to be happening, but you know, Mpofu, who's representing the former president, is taking it back to January. You remember that the matter was set down for the 19th, where President Cyril Ramaphosa was meant to appear in the dock as an accused, the same way that Billy Downer and Karen Moore did with the arms deal trial. But then the president instituted an urgent court interdict within the civil court. You'll remember Zwanele Manye talking about red robes and black robes, and
it was a lot.
and when you wear different robes. So this is an issue of jurisdiction. Now, one may wonder, why are we still talking about jurisdiction when, you know, the urgent interdict was granted and then the president didn't have to stand in the dock? I beg your pardon, Mpofu was arguing today that this actually is intertwined, because this is one court matter, number one, but also it's setting a bad precedent in many ways, but also compliance with Section 106(1)H of the Criminal Procedures Act. They're arguing that an accused does not get to choose when they, for an example, have to plead or not plead. The Act is very clear. In the same way the Act is very clear that when dealing with criminal matters, you have to go to the criminal courts, and civil matters must be dealt with there, because the one court deals with matters, the criminal court, you have to prove beyond reasonable doubt, whereas in the other one you just have to prove certain arguments when it comes to the case. So this is why then the issue of jurisdiction was discussed, and that the president, the incumbent that is, had no exceptional circumstances to actually take his interdict to the civil court.
A lot to take in, and I'm sure there'll be many more developments from this story. For now, Ziyanda Ngcobo, thank you very much for summing up what's been an interesting day of events in court today in the High Court between the former president and the current president of the country.